Welcome to Constitutional Chisme.
A law buddy's guide to the legal basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure to pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one.
This episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan for bar prep, be sure to use our code PASSWITHPONZ, that's PASSWITHPONZ, to save an additional $100 off of your course. This $100 off will stack on top of any other promotions that Kaplan is running at the time. And using this code not only saves you $100, but allows us to continue to give away bar prep for each testing cycle.
We also want to let you know that the promo code to save $100 off the Kaplan Bar Prep will also work to save 20% off of the following products. So if you are taking UBE and you're taking the LLM bar review, it'll save you 20% off that. Anything with LLM, Fundamental Course on Demand, MBEQ banks, flashcards, PMBR, MBEQ banks, bar instant essay graders, any of those items will qualify for 20% off as well. So just use our code PASSWITHPONZ to save money because we want to save you some money.
And speaking of saving money, you can also save 10% off of a subscription to UWorld with code Ponzanelli10. That's PONZANELI10 to save 10% off a subscription to UWorld multiple choice questions, which I swear by.
Perfect.
The other big update, I've officially made a TikTok to go along with the podcast. So now when we plug our little TikTok pages, I'm also going to plug me, my personal one. Yippee!
Watch you surpass me in like a week.
Yeah, watch me be the one that blows up.
They're like,
I am going to try to make content. We'll see how that goes. I make no promises on how consistent I'll be. I have an iPhone and a dream.
That's all you need these days.
Period. And I've always said that.
Listen, like something about me, that's all I have as well.
And catch me in a year being like that one influencer walking around a grocery store going, what is this? What is this?
Oh my gosh, I know what I needed to bring up. I forgot. So remember when you always told me like, when you're rich, there will be signs.
Yeah. You won't know, but there will be signs.
Okay, well, I need to let our listeners know that I have seen a sign of you being rich.
Me?
Yeah.
Oh my God. What?
I heard, and I don't like to start rumors or anything. I'm not like that. I heard you
Is this about my 7 brew habit?
You buy 2 coffees a day.
No, I don't. That is
a flex.
That's fake news. That's fake news. Check your sources.
And I did. She works with you.
And she's wrong. She's a liar.
Listen, that was a sign. So, y'all.
That is not true. For clarification, I buy 2 coffees on one day of the week. One.
In this economy, that's crazy.
I spend $14 once a week in this economy.
That's more than minimum wage. So, yeah. That's double minimum wage.
Okay, I can't help that the federal minimum wage is insanity, okay?
Why you're not doing your part?
I am doing my part. I'm contributing to the economy. But on Tuesdays at 7 Brew, it's double points. So I have an hour and a half commute to work. So on Tuesdays, I get a medium coffee to drink on the way to work. And then I get basically a deconstructed energy drink for when I get to work.
Mm-hmm. How does it
and
feel
that's
like
it.
being out of touch?
My God. Please.
I can't wait for the comments to eat you up. You're going to get more
Please
followers
stop.
And be like, I love a rich girl.
No, because listen, it's economically logical. It's girl math because it's basically, because it's double points. So I'm basically buying, quote unquote, 4 drinks under 7 Brews rules.
Mm-hmm. Mm-hmm. Yeah.
and then I get a free drink.
Yeah.
So,
I'm not even gonna ask
grandma,
you how much you spend a week on coffee. So
$14. I just told you. I spend
for the whole week.
$14.
The whole week, you
Yeah.
single other coffee,
Nope. Usually not.
Monday through Friday.
No.
Mhm. And I know if anyone works at Seven Brew where she's at, Harleigh, please clock her when she comes in any other day. Please
I said
tag.
usually. Every once in a while, I'll get a little treat.
Okay,
But
then she comes out. They're gonna start tagging you. They're gonna be like a sighting.
she was
There's
here
Harleigh.
again.
Yeah. Well, if anyone sees you now that you have your personal TikTok, just tag her.
Oh my God.
You serious?
Please. At
Um,
Seven Brew sponsor me. Clearly, I'm spending buku's bucks at your place.
so now you know Harleigh is rich. She spends 14 a week.
$14 a week.
Hmm.
Yeah, honestly, the money changed me. I don't know what to tell you.
I'm glad that it changed you. You always knew it would.
I knew it would, and I said that from day one. The money will change me. Okay, so today we are going to be talking about a case that you've probably heard of, even if you are not in law school, even if you don't realize that you've heard of it.
Mm.
So, today we are doing the case of Miranda versus Arizona, which was a 1966 case from the Supreme Court. So, backing up a little bit, I want to talk about how we kind of got to the actual case itself. So, before we dive into the specifics of this case, I do want to give a trigger warning for sexual assault. There will be a brief mention of it. It is not in the entirety of the case, but it is in some of the factual background. So, if you do not want to hear that, I would skip forward a little bit past the background section of this case. So, with that being said, on March 13th, 1963, Ernesto Miranda was arrested by the Phoenix Police Department on circumstantial evidence which linked him to the kidnapping and rape of an 18-year-old woman 10 days earlier. So Miranda was interrogated by police officers, and after 2 hours, he signed a confession to
Oh,
the rape charges, which stated, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me."
wow. He just signed all that and was like, okay.
Yeah, so he signed that, and it also had all of the details of the actual crimes that he was accused of. But at the bottom of the form, it had that statement typed out.
Hmm.
Now, importantly, Miranda was not told this information out loud. So he was never told any of those rights, and he was specifically not told that he had a right to counsel.
Hmm. When do you have a right to counsel?
So you technically have a right to counsel as soon as you have been arrested for a crime under the Fifth Amendment. And then once the actual case against you has begun, you
Hmm.
still have a right to counsel, but it becomes a right to counsel under the Sixth Amendment.
It transitions over. Okay.
Yes. So the Fifth Amendment is more generally associated with the right against self-incrimination. So, like, when people get asked a question, they say, "I plead the Fifth."
Hmm.
But the Fifth also provides you with a right to counsel when you are accused of a crime.
Okay. And then it
So
transitions to the six once you're already like in custody.
once you get to the trial phase,
Okay.
and there's a whole separate test for when it goes from Fifth to Sixth Amendment right to counsel. But because this was prior to Miranda going to trial,
Hmm.
this case will primarily deal with the Fifth Amendment right to counsel. So he was not informed of his Fifth Amendment right to counsel.
Okay.
And before being given this form
Hmm.
and being told, hey, everything that you just told us out loud, write that thing back down and then sign it.
Mhm.
They did not tell him that he had a right to not speak to the police. They did not tell him at any point during the interrogation that his statements could be used against him. The only time that language was given was at the end of this form in typed font down at the bottom of the form.
And why does that matter?
So we're going to get into it with this case specifically, but essentially, the Supreme Court makes a very big deal about the fact that you have to have knowledge of what you're signing away. And
Mhm.
this little typed statement simply doesn't cut it.
Okay.
So prosecutors offered his written confession as evidence, obviously, and
Mhm.
his court-appointed lawyer said that the confession wasn't actually voluntary under the facts and should be excluded.
Mhm.
But the trial court disagreed, and Miranda was ultimately convicted and was sentenced to 20 to 30 years of imprisonment on each charge, with the sentences to run concurrently, which
Oh,
basically means they run at the same time.
wait. So if they started the clock for the 20 and then they started the clock for the 30, it would start at the same time and he would basically just end up having 30 years? Or does it equal 50? Like you serve 20 and then you serve 30?
So when it runs concurrently,
Mhm.
the clock starts on both at the exact same time. If
Oh, okay.
they are sentenced consecutively, it would be a total of 50 years. So the clock for the second one can't start until you've served the first one.
Okay. So 30 years would be like the max that the person's in there in this.
Yes.
Okay.
So his his same lawyer filed an appeal to the Supreme Court of Arizona, again arguing that the confession was not voluntary and that it shouldn't have been brought before the court at all.
Hmm.
But the Arizona Supreme Court said, nope, we think it was fine. Everything seems kosher here.
Yeah.
And they specifically emphasized the fact that Miranda didn't specifically ask for an attorney. So there was no issue here. They decided to take it all the way up to the big Supreme Court. They said, forget the Arizona Supreme Court. We're going to the United States Supreme Court.
Hmm.
And on June 13th, 1966, the Supreme Court issued a 5-4 decision in Miranda's favor that overturned his conviction and remanded his case.
I have unfortunately heard of another case with the 5-4 decision, and that is all I have to say about that.
And that is all I have to say about that, which means that it's a very close decision. And,
Hmm.
Stephanie, you would think when it comes to constitutional issues, particularly when you're looking at the plain text of something,
Hmm.
it would be a little easier. But
Yeah.
that's neither here nor there. So, anyway, so 5 justices formed the majority,
Uh-huh.
and the opinion was written by the then Chief Justice Earl Warren.
Hmm.
And the court essentially ruled that because of the coercive nature of the custodial interrogation by police, no confession could be admissible under the Fifth Amendment self-incrimination clause and Sixth Amendment right to an attorney unless a suspect has been made aware of his rights and the suspect has then waived them. So specifically, the court said, quote, the person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation, and that if he is indigent, a lawyer will be appointed to represent. So Miranda's conviction was overturned. And the court made clear that what must happen if a suspect chooses to exercise those rights, saying, quote, if the individual indicates in any manner at any time prior to or during questioning that he wishes to remain silent, the interrogation must cease. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. At that time, the individual must have an opportunity to confer with the attorney and to have him present during any subsequent questioning. So I want to back up a little bit and look more at that language specifically where they said the coercive nature of custodial interrogation.
Mhm.
So the court will have cases later on that kind of dive into what that actually means. But
Mhm.
those are the important words when it comes to the holding in Miranda, because a person does not have to be what is now called Mirandized
Mhm.
until they are in custody.
Mhm.
So, for instance, and again, the court will go into this in later cases, if you get stopped on the side of the road
Mhm.
for a brief questioning, like the police just have a couple questions for you, you are not in custody.
Uh-huh.
But if they walk up to you and say you are under arrest for larceny, I don't know, whatever crimes you commit for fun, when you become arrested, once you are in custody, that's one way to be in custody. It's kind of the quintessential way to be in custody. That is when the police have to give you your Miranda rights. And that's why I say everyone knows this case,
Mhm.
because that language from the court probably sounds familiar if you've ever watched, I don't know, any episode of SVU,
Yeah.
any episode of Law and Order, any cop show ever, 21 Jump Street, any of them. You know the Miranda warnings.
Yeah. But isn't it true that it doesn't have to be like word for word the Miranda warning? It can be like a quick summary.
Yes. So there's the like quintessential speech that everybody knows.
Mhm.
You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. You understand these rights as they have been read to you. That's kind of like the script, and
Mhm.
that's kind of like the A+ work
Yeah.
for a cop.
Mhm.
And that language comes directly from the Miranda case.
Yeah.
So it's everything that Justice Warren laid out in his quote of what a person actually needs to be made aware of,
Mhm.
and then what the limitations of an interrogation are if those rights are invoked. But again, the court will continue to add on, which is very unsurprising given that this is a 5-4 decision. So this is
Yeah.
clearly not something that all of the justices agreed upon. But as the time goes on, they will sort of clarify that it doesn't have to be that exact script. As long as you get across that someone can be quiet and that they can have an attorney, then they have been properly Mirandized.
I think something that I like to let people know in the podcast is we're not debating whether or not this man did the crime that he was accused of.
Yeah, so it's not about was Ernesto Miranda guilty of this crime. It's were his rights protected leading up to the trial?
Mhm.
Was his confession one that was given voluntarily?
Mhm.
And was he aware of the rights that he had before he gave that confession?
Yeah. So I feel like it's hard whenever we have like these terrible crimes that come along with it to understand why we're like, hey, this is extremely important. But having the Miranda warnings helps a lot of people.
Yeah, it provides protection, and it provides another check precisely for people who may be falsely accused.
Hmm.
Because there have been plenty of examples of people giving false confessions
Hmm.
under police interrogation. And
Yeah.
so it's very important that every single person who goes through the process understands what their rights are, even if they have committed a crime. Because even people who are guilty of crimes still have rights that
Hmm.
need to be preserved and protected. And in fact, I think it's worth noting that Miranda's case gets overturned, but it just gets remanded back for another trial without his confession.
Hmm.
And in fact, he's found guilty again.
Yeah.
So it's basically a safeguard that is meant to exist to prevent innocent people from going to jail for crimes they did not commit.
Mhm.
Because even without this confession, they still had the evidence to back up that he had committed this crime.
Yeah. Yeah, and, like, we don't know what anyone does to get the answers that they want, whether they're true or not, you know? I mean, now things are changing a little more, and we're having more and more officers wearing body cams and stuff, but, like, the interrogations were very scary, are very scary. You don't know what's happening, you know? And so just checking in, making sure. Now, something I do have a question about
Yeah.
is how do we know if they're given their Miranda warning and then they confess? Like, how do we prove eh, let's say I have a client and they're like, "No, I asked for an attorney," and then this person has made up this story and said I did this, but like, "No, I asked for an attorney. I didn't say any of that." How does that work?
So it will depend a little bit, not to give the law school answer of it depends,
Yeah.
but essentially that then becomes an issue that a defense attorney is going to have to bring up, typically in a motion to suppress.
Mhm.
And then if they fail to get it suppressed, if the judge disagrees or they don't find the defendant's claim to be viable, like they don't necessarily find it to be supported, and they
Mhm.
say, no, the confession comes in anyway, you then get a chance to present it to the jury as, hey, I don't think that this happened the way the police are saying it happened. And that's where you'll get into, you're going to have the opportunity to cross examine or direct examine if you call the police yourself
Yeah.
and ask those questions if you take it to trial. So there's kind of a couple of avenues to try to get things like that tossed out if there's a discrepancy and there's nothing, for whatever reason, especially in modern times, it's very, very rare that a interrogation or an interaction with the police, like you said, now there's body cams.
Mhm.
A lot of departments require that an officer wear a body cam at all times, where
Mhm.
there's cameras on their patrol vehicles. And I cannot think of any examples of police stations where interrogations are carried out where there would not be, cameras present during the recording. I mean, during the interrogation, pardon me.
Mhm.
But if there is a scenario where they're like, the cameras weren't rolling and they didn't give me my Miranda rights, or they did give me my Miranda rights, I invoked them and they ignored that crap, like, there are a couple different avenues that you can pursue.
And another important thing is if they give you your Miranda warnings and you're like, "I'm not gonna say anything," they have to stop. Like, they have to leave you alone. But if you in like 5 minutes are like, "Yeah, yeah, I did it," then they can use that because you volunteered that information. They did not
Yes.
question it. Now they can't do things like there was I can't remember the case, Harleigh, but the guy was like, "Oh no, you left your gun in a playground. I really hope no one gets hurt there." That's
Yes.
victory. And
So
that's all
that's
leave
where I
it.
talked a little bit about, like, the language of custodial,
Yeah.
but then what is an interrogation?
Yeah.
That's a whole other case. That's a whole other, like, branch of cases that the Supreme Court ends up
Yeah.
having to cover because, for instance, asking somebody their name may not be an interrogation, but asking somebody where they were on the exact date and time that John Smith happened to get shot,
Mhm.
that's probably an interrogation.
What do you mean? I was just wondering where he was that day.
I was just wondering what you were up to. It's just small talk. Oh my god. Literally chill.
No, because of the way that sometimes they try to make it like, "No, that's really small talk. I was not trying to interrogate." I'm like, "Girl, were you lying?"
Girl, why are you lying?
Yeah. If you guys get pulled over and they give you your Miranda, this is not legal advice. but be like, I want my lawyer. Now, that's what I would say. I'm not licensed.
If you think the police are asking you about a crime, say, I want my lawyer.
Yeah.
I want my lawyer. I will not be speaking without my lawyer present.
Hmm.
This is not this is not legal advice. I am not your lawyer.
Yeah. We are both not your lawyer. So, so just, I forget who said this, but basically shut up and ask for your lawyer.
No, literally. I think it's one of the funniest things that comes up a lot on law merch, like, be quiet and ask for an attorney.
Yeah. Yeah.
Be
Stop.
quiet.
Don't tell them your whole life story. Don't tell them anything. Like, please. I keep
If
watching.
you committed a crime, they are not your friends.
No, they're not. They're even if they try to be like, "No, queen, like, I will try to help you." They can lie. That's another thing, right, Harleigh? Like, they can be deceptive, and that's allowed.
They can straight up lie to you.
Yeah.
There's no rule against that. They can straight up lie. I think this is a great time for me to quote the great philosopher, Lil Wayne.
Uh, okay.
Never, never talk to the cops. I don't speak pig Latin.
We're gonna get canceled by all the cops.
Use that for the song, though, for this.
I will have to. I will have to. Again, this is not stating we're anti-cop. This is just saying we are pro your constitutional rights to remain
You know
silent.
you have rights.
Yeah.
Constitution says you do.
We're just
Okay.
two gals over here trying to save you from prison.
We're just trying to save you from prison time. Maybe. Maybe you deserve prison time. I don't know what you get up to on the weekends.
No, period. And I'm not licensed. I can't help you.
You're just kind of cooked. So, the issue in this case was whether the government is required to notify arrested defendants of their Fifth Amendment constitutional rights against self incrimination before they interrogate the defendants. And the Supreme Court held that the government needs to notify arrested individuals of their Fifth Amendment constitutional rights, specifically their right to remain silent, an explanation that anything they say could be used against them in court, their right to counsel, and their right to have counsel appointed to represent them if necessary. And without that notification, anything admitted by an arrestee in an interrogation is not admissible in court. And the final rule of law that comes out of this case is that government authorities need to inform individuals of their Fifth Amendment constitutional rights prior to an interrogation following an arrest. Boom. That's the case of Miranda versus Arizona.
Great job, Harleigh.
Oh my God, thank you.
I remember when we did this one in Crim Pro.
Yes. And we actually had a discussion in class where he was like, so what would you tell your clients to do if they're arrested for a crime? And all of us were basically like, shut up and ask for an attorney.
Yes.
Everybody together now.
No, literally.
And like I said, this issue gets more and more nuanced as the court addresses it more over the years. And I think that's especially unsurprising given the fact that it was such a close decision.
I think some people might be like, well, what if I didn't do it? Like, I don't care. I'll just talk to them. What's the problem with that?
So here's the problem with that. There are so many instances where people submit to an interrogation and they don't understand that submitting to an interrogation means that they can interrogate you for hours upon hours.
Mm-hmm.
And I don't care how strong-willed you think you are, how smart you think you are. If you're subjected to hours and hours of somebody asking you incriminating questions, there is always a chance that you say something that can be used against you. And if it can, it will be used against you. So have someone there with you who knows how this works and can protect you and your rights.
What if you don't have any money for an attorney?
You can get one. If you cannot afford one, one will be appointed to you by a court of law. And they can't ask you any more questions until you get that sorted out. They have to leave you alone.
Yeah, I think that's important because people could feel like, well, I can't afford one or one will be appointed to you. What does that mean? It means like literally they have to stop and they have to provide someone for you.
They have to stop and they have to do a whole analysis of whether or not you qualify for a public defender. But regardless, they can't ask you any more questions until the issue of your attorney gets sorted out. So be safe, not sorry, ask for an attorney, even if you're 100,000% innocent.
Yeah.
Ask for an attorney. Shut up and ask for an attorney.
Yeah.
Tattoo that on my forehead. Shut up and ask for an attorney. If y'all see me with a face tat next week, mind your business.
At the courthouse.
At the courthouse.
So we would love to thank our sponsors. So Kaplan Bar Prep. Again, if you want to save $100 off your bar prep or you know someone taking the bar exam, please tell them to use our code. That way we will be able to continue to give away free bar prep for future bar exams. Also, we have another code, which is still Pass with Pawns with Kaplan, where you get 20% off any of their supplements. So any supplements that they have, if you're not buying the full course and you just want the flashcards or you just want the MEE grader, use our code. You get 20% off. Save your money. We also have 10% off UWorld. All you have to type in is Ponzanelli10. All of this is linked in the link in our bio. Well, link in our bio or in the show notes.
Yes, depending on where you're listening to this. And that is also where you can find the link to our Patreon, where you can join and get access to bonus content and help support the show. You can also find our Amazon list that has all of our recommended law school essentials, everything that we think that you need to be able to survive law school. And as per usual, Stephanie's wish list, if you're feeling so generous. And then we also still have the Amazon wish list up for a incoming one who is a Latina first-gen law student, and we are hoping to surprise her with lots and lots of goodies as she goes into her first year of law school. So if you have a few dollars to spare, hop on over there and get her something to help her get prepared as she starts the most arduous journey of her life, unfortunately.
Also, follow Harleigh on TikTok.
Oh my God, yeah, you can go follow my new TikTok. It's Legally Harleigh. Yes, I figured it would fit best with, the theme we have going with the whole Legally Ponzanelli, Legally Harleigh.
That's
And
very cute.
my name is Harleigh. So Legally Harleigh. Follow me.
I'll put it in the show notes too. I'll put it in the link tree as well.
Oh my
People
God,
can
stop,
follow
I'm
you.
gonna be famous.
No, yeah. And she really wants you to get me something from my wish list.
That's what I said.
Whenever you can put that on your page, make sure you do.
Oh my God.
All right. Thank you guys. Bye.
Bye.